My name is Jennifer Kuyrkendall Griffin. I am running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, I'm going to be discussing modification of child support. So let's start with the effective date of the modification, meaning how far back can the court go to modify the child support obligation. Generally, the new amount of support will be effective as of the filing date of the supplemental petition for modification of support. But if the modification was filed because the obligor parent, which is the parent paying support, reduced or stopped exercising time sharing, then the modification date can actually go back to when the parent first failed to regularly exercise the court-ordered or agreed time sharing schedule. In order to modify support, one must prove what's called a substantial change in circumstances. The child support guidelines alone may be enough to prove a substantial change in circumstances, but the burden is different depending on whether the Department of Revenue is involved or not. If the department is not involved, let's call that a private case, then a 15% difference or $50, whichever is greater, is enough for the court to find that the guidelines provide a substantial change in circumstances. For cases involving the Department of Revenue, the threshold is actually lower. So if the difference is at least 10% but not less than $25, that can be the substantial change in circumstances. The department is actually required to review all of their child support orders in Title 40 cases every 3 years or when requested by a party to see if a modification is appropriate. But what else could be a substantial change of circumstances besides the dollar threshold? Now, the things I'm about to talk to you are examples, and by no means are they an exhaustive list. So, as an example, let's say when child support was established, the obligee parent, meaning the person receiving support, was paying $400 per month for childcare. Well, daycare is included in the child support obligation and is going to raise the obligor's child support if the obligee is the one paying the daycare. Now remember, obligor is the one paying, obligee is the one receiving support. So once the child no longer attends daycare, the obligor could file for a downward modification of child support. Another example, what if the obligor was in school when child support was calculated and the court imputed a low income for purposes of calculating support? But now the obligor has graduated, has an advanced degree, and is making great money. Well, the obligee could file for an upward modification of child support. Other examples that could result in a change in circumstances are paying for health insurance when you previously were not paying for health insurance when support was initially calculated. That could result in a downward modification because you are given a deduction from your income for your own health insurance expense and then a credit against the support obligation for the health insurance expenses for the child. Now remember, these are just a few examples. There are many, many more reasons that could justify a substantial change in circumstances. I tried to use examples that, based on the dollar amount alone with my actual example, would result in the requisite dollar threshold for a statutory definition of change in circumstances. But you would really have to run the child support guidelines to make sure it fits your circumstances. If you Google Florida child support guidelines, then you can find online calculators, or your attorney could calculate that calculation for you. If you found this information useful or know someone that could benefit from it, please like and share and follow the campaign's social media. Do you have a particular topic that you would like me to address? Send a message through the campaign's social media or website. I'd be happy to film a video on the topic you request, but just remember, I can't talk about specific facts or a specific case. I can only speak in an educational manner. If you ever miss an installment of Scales, visit the campaign website to see all of the Scales videos that are available. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.